During pretrial testimony, the doctor swears he did nothing wrong. Can his attorney use that testimony in order to get them out of the case in a motion to dismiss? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So this is a medical malpractice case, and during the course of the litigation, I will have an opportunity to question the doctor that you have sued, the doctor who you believe violated the basic standards of medical care. And during the course of that questioning, I'm going to ask the doctor whether he believes he violated the basic standards of medical care. And what do you think he's going to say? Of course I didn't. I did nothing wrong. That's typically what they're going to say. But then I will have an opportunity to ask him hypothetical questions. The moment the doctor turns around under oath and swears, I did nothing wrong, and in my opinion, I did not deviate from the standard of care. Now, after this deposition is over, his attorney can go ahead and ask the court to try and dismiss our case. And as part of the testimony to support, as part of the evidence to support that request to dismiss our case, can the defense lawyer use his own client's testimony in support to say, hey, there's no validity to this case. Mr. Oginski's client's case is not meritorious? The answer is, yes, he can. He can use that sworn testimony to validate and support his claim that his client did nothing wrong. And why can he use that to support it? Because in New York, a medical doctor who's being sued in a medical malpractice case is viewed as an expert. And regardless of whether he's board certified or not, the law looks at him as a medical expert, somebody with significant advanced medical knowledge and training. So that's why the defense attorney can use the doctor's own testimony to try and get him out of the case. But that's not sufficient. It's not enough. In all likelihood, the defense attorney is going to have to get his own medical expert, who they call an independent expert, who has reviewed the records, to then give an opinion about why he believes their doctor did nothing wrong. Then, what will happen? Then we have to have our own medical expert rebut the claims that are being made by the defense, and to show why we believe that the doctor did in fact violate the basic standards of medical care. Then the judge will have to decide whether we are more likely right than wrong. And if the judge decides in our favor, what he'll typically say is that this is now a jury question. It's an issue of fact for the jury to decide. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in a medical malpractice case here in the state of New York. You know, I realize you're watching this because you've got questions or concerns about your own particular matter. Well, if your matter happened here in the state of New York and you've got legal questions, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.